The Toledo Alcaldes Association is taking the Government of Belize to court. In January, the Attorney General removed and appointed an alcalde and deputy alcalde in Indian Creek Village, Toledo District. The TAA filed for permission to bring judicial review proceedings following GOB's decision. The association asked the court to order that newly appointed alcaldes not proceed with any of their functions until the matter is heard. According to the TAA, the decision by government is a violation of their customary rules and constitutional rights. Christina Cook is the spokesperson for the association.
As the rest of Belize knows, in Toledo, all 41 communities practice a system of traditional governance, which has 2 alcaldes in each village. This is an important system of governance for us. It has sustained our communities since time immemorial. And so we think that it's really important for us to protect and safeguard what has always kept our communities.
Senior Counsel Marshalleck is representing the government. It is no secret that the village councils and alcaldes are not always seeing eye to eye in the 41 communities within the Toledo district. It has been a long-standing issue, but the Constitution does not recognize the traditional alcalde system.
And the issue for the government is whose recommendation do I pay heed to when making the appointments, whether it's a duly elected village council or whether it is votes from village meeting, which they say is their customary practice.
How is it that the government can intervene in customary practices such as the alcalde system?
How is it?
Yeah.
The Inferior Court Act provides for the government to appoint an alcalde to preside over the Alcalde Jurisdiction Court, which is a court equivalent of a magistrate's court. So it's basically the same way it intervenes to appoint magistrates over your magistrate's court who preside over you. It is an exercise of the sovereign right to govern this territory.
The TAA contends that the government cannot appoint alcaldes to the jurisdiction court without recommendations made during village meetings, which is its customary decision-making process. Much like it is with the case of customary land rights, TAA argues that while it may not be recognized by law, it is their right to exclusively determine who will fill these positions. Senior Counsel Godfrey is representing the TAA in this matter.
And our response to that is and will be developed that in the same way that way back when the Maya first advocated for protection of customary land tenure, it wasn't recognized in the laws of Belize. So too, we're saying that the right of their villages to exclusively determine who will be their alcaldes and the right to remove them vests in the village, not by virtue of any written law of the land, but by a process of constitutional interpretation utilizing international treaty obligations and international customary law.
Because currently you don't have an alcalde's law, then once all of this is sorted out, that's the direction you'd want to go, to have the government enact such a law.
Well, we're not concerned. I can't speak for the government. We're concerned with Belize, the state of Belize, and the courts recognizing and protecting the rights of indigenous people to a variety of things, though that will evolve over time, clearly. But we're not speaking for the government. Have a right to legislate what they want, provided it doesn't impinge or erode or subvert the rights of indigenous people.
Marshalleck refers to the challenge as an attack on sovereignty. He explained that the outcome of this case may have varying implications.
What it is an assertion of customary rights and a right to what they call internal self-governance. It's going to impact all of us. The state of Belize is all of us. So what it's saying is that when we vote on elected representatives and give them the authority to make laws, there will be restrictions on what they can do in relation to these villages.
Reporting for News 5, I am Paul Lopes.